Welcome to the Supreme Court Podcast.
All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
The Supreme Court en banc also during its session last August 20, 2024, approved the guidelines on submission of electronic copies of pleadings and other court submissions being filed before the lower courts pursuant to the efficient use of paper rule, also known as the guidelines for e-filing.
And that's Attorney Camille Ting, Supreme Court spokesperson, announcing on August 26, 2024 that the Supreme Court has approved e-filing guidelines for civil cases in trial courts. Today, we will discuss how these guidelines will affect how parties and lawyers file their cases in court. Hi, I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. It's the 30th of August 2024, and with me is Supreme Court spokesperson, Attorney Camille Ting. Hi, Attorney Camille. Welcome to your very first podcast.
Hi, Attorney Mike. Hi, everyone. Thanks for having me.
So, Attorney Camille, first of all, can you tell us why there's a need for new e-filing guidelines and what are these guidelines all about?
So the e-filing guidelines is part of the Supreme Court's efforts to digitize its processes. Under the Court's Strategic Plan for Judicial Innovations 2022 to 2027, or the SPJI, one of the target outcomes is innovation. A key activity under innovation is the development of eCourt System version 2.0 to be implemented in 6 components. The first component is the digital filing and service of all pleadings, motions, and other court documents in civil cases. 2 is the installation of digital case dashboards in all trial courts. 3, the digitalization of existing case records or rolios in all pending cases. 4th, the digital filing and service before the Supreme Court and appellate courts. 5, digital appeals processes. And 6, digital criminal and special proceedings.
So, Attorney Camille, it seems like there's a phase to the innovations that the Supreme Court is trying to do. When we talk about e-filing guidelines for the first phase, this is on civil cases, do we have a timeline for this?
Yes. So the implementation of the first component, which is electronic filing, will begin on September 1, 2024, with full implementation completed by December 1, 2024. So starting September 1, 2024, trial courts shall only act upon pleadings and other court submissions in civil cases if the filing is accompanied by an electronic transmittal of the same document in portable document or PDF through email. So this is what we call the transition period. The goal is that by December 1, 2024, electronic filing will be the primary mode of service, which means that you don't need to file hard copies except for initiatory pleadings or those pleadings that you file to start a case.
But do these guidelines apply to all cases?
No, the guidelines only apply to civil cases.
What about criminal cases?
There is no time frame yet for when the same e-filing requirements will be applied to criminal cases.
And in terms of scope, do these guidelines apply only to lower courts, at least for now?
Yes, so these guidelines will only apply to the first and second level courts. So the first level courts consist of the metropolitan trial courts, the municipal trial courts in cities, the municipal trial courts, the municipal circuit trial courts, and the Sharia circuit courts. On the other hand, second level courts are the regional trial courts, the family courts, and the Sharia district courts.
So nothing about Court of Appeals, nothing about Sandigan Bayan, nothing about any other court.
No, that will be at a later stage. It's a different component of the e-court.
All right. Now, so during this transition period, which is from September and before December this year, when parties are required to submit their pleadings also via email, aside from, of course, the physical filing through personal service, registered mail, or accredited courier, all of these steps are mandatory, Attorney Camille. Just to say, you cannot skip any of the process, either the physical filing and the electronic filing.
Yes, that is correct. So, the physical filing, whether it's by personal filing, registered mail, or accredited courier, must be accompanied by an electronic submission of the same. And the electronic submission must be completed within 24 hours from the primary manner of service. I would also like to note, Attorney Mike, that under the guidelines, a court may waive the electronic transmittal requirements if the annexes, exhibits, and other accompanying documents cannot readily be converted to PDF or if these consist of sealed and confidential documents.
So there are instances where parties may be exempt from submitting an electronic submission of pleadings. Can you walk us through the process, Attorney Camille, of electronic filing? For example, if I'm the lawyer, what am I supposed to do when I'm going to comply with the e-filing guidelines?
Okay, so after completing the primary mode of filing, whether it's again personal filing, registered mail, or accredited courier, parties have 24 hours to make the electronic submission. They can either scan the documents or convert them to PDF. They should save each document as separate files following the prescribed file name format. They can then email these to the court's official email addresses. They should also follow the prescribed format for the email subject as well as the body of the email.
So how should the subject of the email look like?
So the subject of the email shall contain the docket numbers, case titles, and the designation of the primary pleading or court submission being transmitted, including its nature. So for example, it will look like this: civil case number 123456, comma, Maria de la Cruz versus Juan de la Cruz, dash, complaint for unlawful detainer.
And what about the body?
In the body of the email, they must state the following: the primary manner of filing, which is either personal filing, through registered mail or accredited courier, the filing date, the docket number, the case title, name of the filing party, contact numbers, and titles of the attachments.
You mentioned attachments, Attorney Camille. What if the attachments exceed the maximum size allowed by the email service provider?
In case the total file size of the documents exceeds the maximum size allowed for attachments by the email service provider used by the filer should transmit the electronic documents in several batches. But note that each email must be clearly marked by indicating in the subject the batch number of the email and the total batches of emails sent. So example, 1 of 3, 2 of 3, 3 of 3, following the prescribed format in the guidelines. I also have to add, it is the responsibility of the filer to ensure that the receiving court's official email address service will not reject or block a transmittal email due to its size.
So they have to make sure that it's in compliance with the limits of the service provider.
Yes.
What about multiple cases? Can you send a transmittal email, just one transmittal email, containing pleadings in multiple cases?
No. So a transmittal email should contain only PDF copies pertaining to one case. So for the purpose of filing, consolidated cases with more than one docket number shall be considered as one case. All files must be enclosed as individual attachments to the transmittal email.
So now you have all the documents ready, you attach it to your email, you're ready to send it. Which email address should be used to send court submissions?
Okay, first of all, the counsels must file a notice of appearance in all civil cases pending before the trial courts containing the valid and professional email addresses of all counsels, their law firms, if any, and the parties. So these email addresses contained in the notice of appearance shall serve as the email addresses of record. An email address is deemed valid when it is in this format or syntax, a name or local part at domain. And it has to be capable of receiving emails from other senders, especially those outside the address's own domain. Counsels on record are required to use their professional email accounts as their email addresses of record. Now, to preserve the confidentiality, privacy, and security of communications, the use by lawyers of personal or non-professional email accounts as their email addresses of record is prohibited.
So you can't, Attorney Camille, you can't use like a pseudonym when you file an email, or maybe perhaps a literary character as your email address.
No. So again, a professional email address must be used. So I'd also like to say that counsel and parties have the obligation to monitor the inboxes of their email addresses of record with the courts regularly and diligently. Failure to do so shall subject them to disciplinary action.
Is this why there's a requirement, Attorney Camille, that other than the lawyer's personal email, there has to be an email of the law firm as well indicated?
Yes, if any.
So, Attorney Camille, you said that we need to use the email of record. What happens if you transmit to an email that's not of record.
So if you use an email address not of record, it will be deemed as not received until such time that you transmit the document using a valid email address of record.
So, how about the email address of the parties? Are these required?
So the submission of email addresses of the parties is optional but highly encouraged.
What about the email address of the court? How do we know that that's the correct email address for the court?
So the official email addresses of the court is available at a directory found at the Supreme Court website, particularly under the tab Court Locator.
Now, what happens, Attorney Camille, if the email is not sent because the attached documents are too big?
So the size of each PDF must be reasonable. The one filing is responsible for ensuring that the receiving court's official email address will not reject or block a transmittal email due to the file size of the attachment. Other parties or counsel as recipients are responsible for ensuring that they will also be able to receive a transmittal email.
How do you prove the receipt of electronic copies?
So you prove the receipt of the electronic copy when it is part of the case record or rolio. So the clerk of court or branch clerk of court shall have the primary responsibility to ensure that all pleadings and other court submissions electronically transmitted to their court are properly accounted for and are included in the case record or rolio.
And this is a practical matter, Attorney Camille. Would you recommend, for example, if I'm a lawyer and I wanted to prove that, look, this email was sent on this time before the deadline, would you recommend printing the transmittal email or perhaps getting a screenshot of the exact time when the email was sent?
Oh, well, yes. It would be advisable if the lawyer would print a copy of their transmittal email or save a PDF version of the transmittal email to keep on record so that they can show that it was indeed transmitted.
Before the deadline. The question now, Attorney Camille, we have all these programs, we have all these projects, phases for innovations. Are the judges and court personnel ready?
The Supreme Court has an infrastructure for its digitization efforts, which is the Philippine Judiciary 365, or what we call the PJ 365. So it is a communication and collaboration platform, which includes, among others, email as well as cloud storage.
And are they trained though? I mean, we know of many judges who may not be so young to embrace technology. Are they ready for this?
Well, the Office of the Court Administrator has conducted a number of webinars to orient the judges and court personnel when it comes to e-filing. However, the OCA will continue to do so, and under the guidelines, all judges shall also ensure adequate training for their personnel in the digitization of existing case records of pending cases. Also, the Philippine Judicial Academy is tasked to create courses that will continually orient and train judges and court personnel in all components of eCourt version 2.
Will the Office of the Court Administrator also provide technical support in case there are problems?
Yes, right now, so tech support is going to be real-time, to be provided by the Office of the Court Administrator and the Management Information Systems Office through the email tech.support.spji@judiciary.gov.ph. By the end of September, each regional court manager and each court station should likewise also be able to provide tech support.
Attorney Camille, one of the big concerns when a company or a government entity goes digital is data privacy and security. Are there concerns in the possibility of data breaches?
So the court assures the public that in its current efforts to digitalize court processes, the court has always given top priority to cybersecurity, and it has taken the necessary precautions in terms of training, access, and the use of needed applications and hardware. So we have layers and layers of in-house and external cybersecurity. So we are aware that hacking data from institutions such as the judiciary is very tempting. So we would like to remind the public that our systems are professional, state-of-the-art, robust, and capable of identifying and tracing the sources of any form of attack. We would also like to remind the public that any attempt to gain unauthorized access or to compromise our systems, as well as releasing sensitive and private data without proper authorization, are criminal acts.
Right, so they're warned. We see you. Right. It's a good discussion, Attorney Camille. Thank you for joining us today.
Thank you very much, Attorney Mike.
All right, and if you want to know more about the e-filing guidelines, you may visit the e-filing microsite on the Supreme Court website, where you can access the full text of the guidelines, infographics, and the relevant videos that can serve as reference. So now here's Stiff Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
At the Supreme Court this week. The Supreme Court has ruled that decades-long unjustified absence from the marital home may be considered evidence of psychological incapacity to comply with marital obligations. The court declared the marriage between Leonora and Alfredo void, ruling that Alfredo's long absence from his marital home showed psychological incapacity, which made him unable to fulfill his marital duties. Under Article 48 of the Family Code, spouses are obliged to live together, observe mutual love, respect, and fidelity, and render mutual help and support. Supreme Court spokesperson Attorney Camille Ting announced during a press conference on August 27 that the court en banc, during its session on August 20, 2024, approved the Unified Legal Aid Service Rules, or ULAS. The ULAS rules govern the mandatory rendition of pro bono legal aid services by covered lawyers to qualified beneficiaries comprising of the following: indigents, members of marginalized sectors with respect to their public interest cases, and non-governmental and non-profit organizations with respect to cases beneficial to indigents and members of marginalized sectors. The Supreme Court Public Information Office will upload a copy of the ULAS rules to the Supreme Court website upon receipt from the Office of the Clerk of Court en banc. The Justice Sector Coordinating Council, or the JSCC, made up of the Supreme Court, the Department of Justice, and the Department of the Interior and Local Government, is launching the JSCC's first Tri-City Justice Zone. On September 3, 2024, the JSCC is launching Cagayan de Oro City, Iligan City, and Ozamis City as the Tri-City Special Justice Zone on anti-online sexual abuse and exploitation of children. The Justice Zone is the JSCC's flagship program and aims to ensure better coordination amongst the 5 pillars of the criminal justice system in the Philippines. 1. Law enforcement. 2. Prosecution. 3. Courts. 4. Corrections. And 5. The community. President Ferdinand Marcos Jr. has appointed new justices to the Court of Appeals on August 29, 2024. These are Associate Justices Ferdinand Bailon, Marietta Bronner Qualing, Mary Josephine Lazaro, and Emilio Rodolfo Legaspi III. The President also appointed on August 28 30 new judges to the Municipal Circuit Trial Court, 19 to the Municipal Trial Court, 24 to the Municipal Trial Court in cities, and 80 to the Regional Trial Courts. For a complete list of the newly appointed judges, visit the website of the Official Gazette. The Secretary-General of the Permanent Court of Arbitration, Dr. Marcin Chepelac, paid a courtesy call on Chief Justice Alexander G. Gismundo on August 30, 2024, at the Supreme Court Session Hall. The day before, the Supreme Court, through the Philippine Judicial Academy, together with the Department of Foreign Affairs, the Ateneo School of Law, the Permanent Court of Arbitration, held a forum with Dr. Chepelac titled The Permanent Court of Arbitration, Its Expanded Facilities in the Service of Justice and Peace at the Ateneo de Manila School of Law. The Office of the 2024 Bar Chairperson extended the deadline for completing the mandatory Sample Assessment 3 until August 30, 2024. This is the final opportunity for examinees to comply. Failure to complete Sample Assessment 3 by August 30, 2024 will result in the deactivation of the examinee's Exemplify account. The non-compliant examinee will be denied entry into local testing centers and will not be permitted to participate in the 2024 bar examinations. Interested participants for the first leg of the proposed amendments to the Rules of Civil Procedure regional consultations on September 4, 2024 in Cagayan de Oro City may register until September 2, 2024, 12 o'clock p.m. following the extension of the registration deadline. The CivPro regional consultations aim to engage various stakeholders, including judges, legal practitioners, and the academe, in discussing proposed amendments to the Rules of Civil Procedure. To register, visit the CivPro Regional Consultations at the Supreme Court website. The court issued a statement on August 28, 2024, that it launched an immediate investigation on the alleged data breach involving the Judicial Electronic Payment System, or JEPS. The court said that it found no evidence of a breach or indication that sensitive data was compromised. The court also assured the public that in its current efforts to digitalize court processes, the court has always given priority to cybersecurity and taken the necessary precautions in terms of training, access, and the use of the needed applications and hardware. The court also reminded the public that any attempt to gain unauthorized access or compromise its systems, as well as releasing sensitive and private data without proper authorization, are criminal acts. The Supreme Court of the Philippines mourned the passing on August 28, 2024 of Judge Toribio E. Ilaw Jr., retired Judicial and Bar Council regular member representing the private sector. He was 78 years old. Judge Ilaw served as JBC regular member from August 24, 2016 until July 18 this year.
And that's your Supreme Court this week. I am Tiffany Dobletran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, and YouTube. You can also catch previous editions on our website. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Jen Tuazon Iranya as writer, Don Ryan Balsa, Victor Laranyo, Brian Austria, and EJ Mejares as sound editors, and Tyke Flores as web editor.